Welcome to this event of the National Point of Contact for Space Law at the margins of the 60th session of the Legal Subcommittee of UN COPUOS. This event will be recorded, and I share my screen which shows the program of our event this evening. It is a great pleasure to welcome you at this side event at the margins of the 60th session of the Legal Subcommittee. My name is Irmgard Mabo, and I am the head of the ECSL National Point of Contact for Space Law Austria, which has organized this evening event with the kind support of the University of Vienna and the Federal Ministry for Climate Action, Environment, Energy, Mobility, Innovation and Technology. We are very pleased about the great interest this event has raised with numerous registered participants. Of course, we would have much preferred to welcome you at the premises of the University of Vienna, for example, at the rooftop of the law faculty with a very nice view over the city center. But we are glad that this year the Legal Subcommittee and with it the side events did not have to be cancelled due to the COVID-19 pandemic, but can take place in this way. The theme of our event is the role of private actors in shaping national space law and policy, dynamics and stumbling blocks. We invited experts of various space sectors to share with us their experiences with the development or review of national space legislation and policy. In contrast to the early days of the space age, national space laws and policies today are often driven by interests and needs of the private sector. This result of commercialization and privatization of space activities reflects the changing role of the state in the exploration and use of outer space. While this is understandable, it bears a risk of fragmentation and custom-designed regulation at the national levels, which may not encompass the broader spectrum and can fail to consider possible future developments. It may turn out at a later stage that the rules are not precise enough or conversely set up too many constraints. Different countries have recently experienced the need to change or amend their national regulatory frameworks. Another question is to what extent space activities today are indeed private. Often public money becomes involved at a certain stage, be it in the form of direct investment in companies and institutions, be it as grants and subsidies, or be it in the role of the state as a customer and purchaser of space-based services. The event this evening will analyze a few examples of space activities which have influenced national space laws and policies. Our four experts will talk about their experiences and share insights and ideas for the future in four different space sectors. First, for launch services, it will be Professor Stephen Freeland from Australia. Second, for space resources utilization, it will be Brian Israel from the United States. For satellite communication services, it will be Elina Moroshova from Intersputnik. And for small satellite activities, it will be Professor Otto Kudelka from the Graz University of Technology, Austria. We will have a talk or interview with each expert on the basis of four almost identical questions, which have been circulated in advance. After that, we will invite questions from you, from the audience, via the chat, or if technically possible, via microphone or video. The event will be recorded and made available online later on the website of the National Point of Contact. Our first speaker is Stephen Freeland, Emeritus Professor of Western Sydney University, Professorial Fellow of Bond University, and co-founder and co-principal of Azimuth Advisory Australia. We have pre-recorded the talk with Professor Freeland, who is currently in Australia, but nevertheless busy as a co-moderator together with Andrzej Mistal in the scheduled informal consultations on space resources for the UN COPOS Legal Subcommittee. We are very grateful to him that he nevertheless was so kind as to agree to participate in this event and share with us his experiences of the role of space launch services for the review and development of the national space laws in Australia and New Zealand. In view of the time constraints, I will have to shorten the talk with Professor Freeland a bit, but the full interview will be made available on our website later on. I apologize in advance for the ensuing interruptions. And just to briefly recall the 4 questions. First, please describe briefly the space sector you are going to talk about. Second, to what extent is this sector private or public? These 2 questions will be answered together in approximately 10 minutes. Then the third question is, how were you involved in the review, development of national space law and/or policy? And which were the biggest challenges? And the fourth question will be, which recommendations would you have for the future? I will now share the screen with you, the video screen. I stop for a moment this screen sharing. I upload the video. Uploaded this already, but I have to share. I hope you can see it already. I hope, yeah. Perhaps I can see, get a message in the chat. If you should see a black screen.
Yeah.
Yeah, okay. So here is the first slide. I skip a little bit of my introduction of Professor Freeland because I've already done it now. So we start here. Please enjoy the interview with Professor Freeland. I will now deactivate my video here because you see you will have a video from of me also in the pre-recorded talk. The floor is yours.
Oh, hello, Irmgard. Thank you so much for that very generous welcome. Hello, everybody at the Legal Subcommittee. Perhaps you're already sick of my face, so this is being pre-recorded, and I understand there's an interested audience in this wonderful event that's being organised by the National Point of Contact in Austria, and I congratulate them. It's a really great idea to focus on these industries and see the interaction between real activities in space and the regulation. So thank you for inviting me. When you're watching this, everybody, it's probably about 2:30 in the morning in Australia. So Irmgard very kindly and mercifully agreed that we could pre-record this rather than me being there live. So I say hello to everybody from Australia. Before I start, let me acknowledge the fact that where I am sitting here in Australia is land where people have lived for 65,000 years. That's over 2,500 generations of people. Our Indigenous people in Australia are renowned as almost being the world's first astronomers and have great knowledge and wisdom and experience with space. And those lessons are important for all of us to learn. And I'm sure that's the case with Indigenous people around the world. So thank you, Irmgard, for inviting me. Yes, I'd like to talk about launch services, because as you say, in the case of Australia and New Zealand, two of the governments that I've had the honour of helping and working with, amongst others, in the development or implementation of their national laws, for those two countries, the impetus for their national law was in fact launch services. So let me perhaps briefly outline why that is the case, why are launch services so important, or perhaps more relevantly, what questions are relevant when one considers firstly whether launch services are appropriate for a country, and then secondly, in the answer to those questions, that will feed into perhaps how the national law might look. So I've got on this slide here a couple of fairly fundamental and basic questions. Launch services, of course, the demand for launch services continues to increase. It obviously is something where safety is of primary concern, because of course launching and then also in the case of Australia returns, particularly times where things could go wrong. And we've seen, unfortunately, that happen a few times over the years. So there are a couple of sort of basic fundamentals that are important for any country that is considering the development of an indigenous or sovereign capability for launch services. I use that expression sovereign capability because that's something that increasingly we are hearing in various countries in these times, particularly, for example, in Australia. Now, there is a great debate about having the capability for sovereign capability in launch. New Zealand, and I'll explain a bit more, already does have that capability. And as I said, in both cases, the law was promulgated as a result of that. So what are these criteria? This capability, working with the regulators, working with the industrial and technical people to develop sovereign capability in Australia. Southern Launch, which is proposing to launch from South Australia into the polar orbits. Gilmore Space, which is proposing to launch from Queensland, and Equatorial Launch Services proposing to launch from the Northern Territory into geostationary and equatorial orbits. Those countries are still in development and working with the regulators. We've had some test launches. Of course, Australia has had in the past Woomera, which still operates, and Australia was, ironically, probably the third country in the world that launched its own satellite from its own territory way back when, from the Woomera range in South Australia. The Woomera range still operates, but is now protected area controlled by the government and controlled by our Department of Defence. And so the three companies I've mentioned there are private companies, commercial operators who are seeking to develop launch facilities and offer these services. Clearly, they work closely with the government, but they are private entities. They are supported by the government by way of grants, by way of regulatory support, by way of licenses ultimately, but they are private entities seeking private capital to develop. New Zealand, everybody would be aware, has already sovereign capability. A company called Rocket Lab is launching from the Mahia Peninsula in New Zealand very successfully. It's launched dozens now of successful launches, concentrating in small satellites going up to altitudes of, I believe, around 500 to 600 kilometers. So that's already operating, and the New Zealand law was designed around regulating that. Again, a private company, but clearly with governmental support in terms of the regulatory framework, in terms of infrastructure support, in terms of a whole range of issues. But you'll see, therefore, in both of these countries, the operators are, in the case of Rocket Lab, and will be, in the case of those proposed in Australia, private entities seeking private capital and competing in the commercial markets.
Thank involved in the development and review of the national space laws and policies, and what were the biggest challenges in this process?
Oh, that's a great question. And let me briefly tell you about the Australian experience and then the New Zealand experience, because as I said, in both cases, they were driven by the idea of a launch services industry. So Australia was, I think, the 6th country in the world to have its own national space law. In 1998. We had the Space Activities Act, and that was legislation that was promulgated at that time because the government of the day felt, when there was interest from consortia, felt that Australia could enter the launch services industry. Indeed, at the time, one of the ministers said that perhaps by 2010, Australia could have 10% of the world launch services industry. That was a statement made by a minister at the time. And so the Space Activities Act was put in place. At the time, as I said, there were very few national laws in place. Irmgard, you know this very well, of course, because you are a leading expert on national law generally. And so the Space Activities Act was drafted with one eye on the then existing US law. And much of the US law that was relevant for launch was looked at and applied in an Australian context in terms of maximum probable loss, in terms of the amount of insurance required, etc. So the Space Activities Act was put together to develop a launch service industry with a sophisticated licensing regime for launches, returns, but also other licenses called, for Australian entities or individuals who wanted to launch from overseas. But in a sense, that was very much the secondary raison d'etre. The main thing was around launch. Interestingly, though, Irmgard, as I said, Australia has still not yet developed the launch industry. So the main driving factor for the Space Activities Act actually has not come about, which is quite strange. Yet the legislation was very useful for other companies, one of our large telecommunications companies, Optus, for example, which launched 6 or 7 geostationary satellites from various countries overseas. And so the overseas launch certificate, now called an overseas payroll permit under the new legislation, was utilized under the Space Activities Act. So the act was useful, it was helpful, but actually it wasn't used for the main purpose, which was launch. Then the Australian legislation, the Australian industry was changing, as was every country, with the development of different types of technology and particularly issues about miniaturization of space technology. So from about 2010 to 2015, the nature of the industry was changing. We still had those geostationary satellites, of course, but there are many smaller companies developing other types of capabilities. And the government of the day just thought that we need to review the Space Activities Act because it was for a certain purpose. Large rockets launched by large companies with big balance sheets, and the industry had changed. So they called on for a review of the Space Activities Act. I was honored. The government appointed me in 2015 to review the Space Activities Act, to make recommendations about how it might be amended to take into account the changed nature of the industry, the changed nature of the types of activities, the changed nature of the actors and other circumstances. So I reviewed the Space Activities Act, put in a report of about 180 pages, I remember, in the middle of 2016. The government took on board my review, engaged in some other consultation processes after that. I'd already had consultation, but this was an ongoing process. And on the basis of initially my review and then other processes within government, the legislation has been amended. It's now called the Space Launches and Returns Act of 2018, which came into force in 2019. It's still very much focused on launch. It's also focused on return, and as people will know, we've had returns. Hayabusa 1 and more recently Hayabusa 2, for example, have returned to Australia under the relevant legislation. It's about launches. It still has overseas payroll permits, but it's now designed, taking into account some of the recommendations I made, but other things that government had, to perhaps be a bit more user-friendly and enabling for the smaller companies with smaller balance sheets. And the, for example, financial requirements for insurance have been decreased significantly from what they were in the original Act. So that's the situation in Australia. In New Zealand, as I said, it was slightly different. They had the launch capability, they didn't have the law. And so initially, New Zealand perhaps didn't aspire to be a spacefaring nation in a significant way. Rocket Lab, which it was an American company, the New Zealand subsidiary, and its CEO is a New Zealand citizen, came to the government, developed a launch facility, actually launched already in May of 2017 under contractual arrangements between the company and the New Zealand government, and there was also arrangements with the US government and the New Zealand government, but they didn't have legislation. So the government came to me already in the beginning of 2016, knowing that this was going to happen. And together with the government, I worked for 18 months in the development of their national law, which is called the Space and High Altitude Activities Act 2017, which came into force in 2017. So this was a reaction to launch. But I have to say, one interesting point was the initial brief was, let's draft and develop together with my assistance of the government, what they would call the Space Activities Act. But then over the period that we were working together, the government recognized that there were other types of technologies, high altitude platforms, pseudo satellites, drones, that were operating in what you might call high altitude. So above commercial airspace, but below what we might regard as space, recognizing, of course, that we don't yet know where the boundary is, but in this high altitude area. And so the brief expanded, and you'll see the New Zealand legislation, of course, regulates launch and has a really flexible and interesting regime in terms of the way it has licenses, but it also regulates high altitude activities. And I think that is a trend that will continue. Other countries will have to do that. And indeed, under the Australian amendments that I mentioned previously, they now also regulate what are called high power rockets, which are defined as objects not intended to go to space, but with particular functionalities and characteristics. And so slowly that trend under the quote unquote space law will also include high altitude. But again, this was driven by the need to provide launch services. So both, I think, interesting experiences, and we shall see as time goes on how they continue to encourage the development of the respective national industries.
Thank you very much. Legislators and policymakers?
Oh, Ungad, again, a really great question. As I said, I've had the honor of working with quite a number of governments in the development or the review or the amendment of their legislation over and above Australia and New Zealand. And in the end, you begin by asking the same questions, but you get very different answers. And that's why the first point I would make would be that the national framework has, I'm stating the obvious here, but it has to suit the particular characteristics of the particular country. We know what some of the headings will be through the implementation of Article 6 of the Outer Space Treaty, for example, and other things under the international framework. So we know what some of the headings will be, but some of the specifics will differ from country to country. So recommendation number one is obviously make sure that your national legislation suits, is fit for purpose. And an expression that I've learned from government, although I don't like it, is perhaps flexible enough and what we might call future-proof. But national law is a balance. It's always a balance. It's a balance for on the one hand, all of the things I've mentioned, safety, international obligations, protecting the environment, implementing things like, for example, the debris mitigation guidelines and now the long-term sustainability guidelines, protecting the national interest, all of those things on the left-hand side of the ledger, incredibly important. But for some countries, and virtually for all countries, but perhaps to different degrees, there's also the desire to develop industry, to make the barriers to entry, particularly in this era of change technology and miniaturization of some technology, lower the barriers, because you're going to have smaller companies or different types of actors engaged in space. Having a licensing system that works, having financial requirements that works, having laws that point the way and then implement best practice and feeding that through and requiring that. Because my experience at the UN process is, of course, all of those best practices from national systems also feed back into the way that international law may be developed. So get the recommendations are getting these balances right. And it is a real challenge to get this right, to find the right answers, because sometimes you might think that some of these issues are slightly conflicting. I don't think they are, but it requires on the side of government flexibility, a clear focus about what it wants, understanding the technology is changing, ensuring that it implements best practice, but also being flexible in the way that, for example, it reviews its legislation from time to time. It takes into account, for example, the changes in technology. One example is the actual definition of launch. You know, we all understood what launch was in the traditional days, but now we have space objects being, if you like, propelled into space, for example, from the International Space Station. And so you need to take into account definitional changes to take into account, you know, is that launch and how does that fit into the legislation? These are legal questions, but they're very much required to be understood and put into a practical framework in terms of the national law. So governments need to understand the changes, be flexible, comply with all of their requirements, understand and take a global view as well as a national view in terms of the consequences of space activities and ensuring safety. On the industry side, particularly in the issue of launch services, because it's got a whole range of safety issues involved, I urge industry, and my experience is they must do this, to be very transparent with government in their plans, to speak with the regulators on liaise with them early on, to have good advisors who understand the law. And the law is not just the national space law. There are other space law, there are other laws that will be relevant. For example, the import of space technology will require import controls, or exporting technology or services or whatever will have export control requirements. And there are other requirements that will arise under the particular country. So
we must stop here. We must unfortunately and impolitely interrupt Professor Freeland here. He has a few minutes left in his explanation of balancing and getting the balance right, which is certainly one of his most important messages here. But we cannot afford listening to Professor Freeland any longer, because also Brian Israel has some time constraints. I just repeat that questions to Professor Freeland's presentation can be sent to us at the NPOC email address. We will put them together and forward them to him collectively. Now I would like to give the floor to Brian Israel, the next speaker. Currently, he's the Associate General Counsel for International Law at NASA. Although today he will share some personal reflections based on his experience in prior roles. Previously, Brian served as a General Counsel of Planetary Resources, a Seattle-based startup developing technologies for asteroid resource exploration, and co-founded Consensus Space, a software company that developed TrueSat, an open source citizen science platform for satellite tracking. Brian served in the State Department as office of the legal advisor for many years and as head of the US delegation to the COPOS Legal Subcommittee between 2012 and 2016. Brian also teaches space law at Berkeley Law. With this brief caveat about the time that we need to stop before 7, it is a great pleasure to give the floor now to Brian. And may you share the screen right now. I hope it works.
Thank you, Irmgard. I'll share the screen in a moment, but just want to say
Yes.
good evening, good afternoon, good morning, depending on where in the world you're dialing in from. I'm delighted to join old friends and colleagues, if only over a computer screen right now. Bear with me as I try and share the slides.
Great, works perfectly. Thanks.
So, Irmgard, did you want to start in with the questions?
Yes, sorry. The first two questions are, please, Brian, describe briefly the space sector you are going to talk about. First question, and second, to what extent is this sector private or public?
Okay, of course. So I'll speak from the vantage point of a former role with a startup developing space resource exploration technologies. And so the views I'll share are personal, not to be confused with the views of NASA or any of my former employers. Now, the general mission of Planetary Resources was to utilize the water resources of near-Earth asteroids to support deeper exploration of our solar system and sustainable orbital operations. So to use that water for things like propellant, for extending the life of satellites, for refueling or fueling interplanetary spacecraft in orbit, for radiation shielding and things like that. And the simple case for sourcing water resources from near-Earth asteroids, as opposed to, say, launching them from Earth, was the prohibitive energy intensity and thus the cost of launching almost anything out of Earth's gravity well. So once you're beyond Earth's gravity well, it's relatively inexpensive in energy terms to move water almost anywhere in our solar system, but getting at that first step off of Earth turns out to be pretty expensive. Thus the the genesis of the idea of sourcing water for use in space from space. I hope you can see this this headline I'm sharing. I think that the public perception of space resource utilization has been shaped to a large extent by headlines like this one, rather sensational headlines, which make great clickbait. They're very good for selling clicks, but they don't track the reality of the use cases being evaluated by public and private players, at least in my experience. So if not for minting platinum quadrillionaires, what is the relevance of space resource utilization? Well, let me see. Go forward in the slide. Even with the cost, with the drop in the cost of launching things from Earth in recent years, realizing the exploration plans of many space agencies around the world will depend in some measure on in situ resource utilization, as opposed to sort of launching everything from Earth. And here I have a statement from the Global Exploration Roadmap of the International Space Exploration Coordination Group. This is, as you can see, the members of ISAC-G. Is a relatively diverse group, both sort of geographically and by many measures, and they come together to coordinate and sort of interoperate space exploration plans. And you probably can't read this on your screen, and so I'll read this this in situ resource utilization objective from the most recent plan. To demonstrate in situ resource production and utilization capability, sufficient for crew transportation between lunar surface and gateway, and lunar surface utilization needs. And the sort of the overarching objective is to expedite sustainability for future human moon and Mars exploration and to identify future commercial markets on the lunar surface. And so you asked whether this is space resource utilization is mostly public or private, and I'd say that ISRU remains a future or a prospective activity, and I see public space agencies as prospective customers for water resources for future missions. And the private companies I'm aware of are mostly engaged in research and development in anticipation of that future demand at this stage.
Thank you very much. This is very insightful. Now the third question would be, how were you involved in the review or development of national space law and policy, and which were the biggest challenges?
Of course. I was involved in the Space Resources Exploration and Utilization Act of 2015 during a prior stint in government service as a foreign ministry lawyer. And my role then was in providing, counsel and technical edits to ensure that the final law conformed, with the international obligations of the United States. You asked about, some of the challenges presented by that law. Well, some of the private sector proponents of that law favored a formulation that would purport to, grant sort of exclusive rights to the resources in place, so to speak, to say a whole asteroid, or to sort of the resources in place in that asteroid, as opposed to rights in sort of resources that had been removed from its celestial body. And that, of course, is not something that a single government acting alone could do, and that's not what the law ended up doing in its final iteration. But it was that's certainly a substantial part of the negotiations within the U.S. legislature over that law. Now, I had the honor of explaining this law to colleagues at the Legal Subcommittee in 2016. And I think that the initial reaction to the law was understandably one of alarm, because upon first reading, it's easy to mistake the law as purporting to, grant rights to celestial body resources in place. But I think, working through those provisions line by line in Vienna, I think delegates came to understand that the law did no such thing and really didn't change U.S. law or policy with respect to space resources. That said, I think, looking back 6 years later, it does feel like the law has changed the conversation around space resources. It feels like it was perhaps an inflection point in that regard.
Interesting, certainly. And the last question from my side before we go on to the chat, and I think there will be some chat questions. We have time for that. But before we go to that, which recommendations would you have for the future, let's say, legislators and policymakers from your side, from your experience in the various roles in government and private sector, now in a space agency?
Well, reflecting back on my time as a foreign ministry lawyer, I personally feel like much of the controversy surrounding space resource utilization in international legal circles was premised upon inaccurate technical assumptions or some magical thinking about the economics of this activity. At least, speaking for myself, I know that, I believed the headlines. I bought into some of the thinking about the abundance of private capital seeking to invest in this activity. And I just sort of assumed that there would be these companies with sufficient capital to carry out the full cycle of space resource utilization. Then, having subsequently spent some time attempting to build a business and finance an asteroid resources exploration mission, I'm a little bit wiser now. But both about the technical dimensions, but also about the business challenges that stand between our present reality and the future state envisioned by many space agencies, in which there will be a commercial market for, say, water on the lunar surface, where space agencies can purchase water resources without the public having to pay for the entire enterprise, for the entire value chain, as with many sort of space exploration programs. And my personal view is if we desire this, if we want in-situ resource utilization to enable deeper, more sustainable exploration of our solar system, we'll need to find a way to allocate transactable rights to the resources in place, so to speak, such that an exploration entity, could obtain rights and sell those rights to a mining entity, and so forth. And this would require, a non-trivial feat of international cooperation. And I think that will in turn require our community to really understand the technical and business dimensions of this challenge and to work constructively toward a solution. I think we've made a lot of progress in that regard in recent years. And I'm really hopeful that this is a puzzle that we can solve together.
Thank you very much for also your personal assessment. Now I would like to invite the audience to put questions. I have seen some interest in the chat, but not a concrete question so far. But now I invite people either to raise the hand if that's possible here, if you can do this, or just write in the chat, I have a question. Then I can also give the floor and you unmute your microphone. We have 10 minutes for questions. That's great. Brian was very brief in his overview, so we have a lot of time for relatively much time for questions. Is there any? Or if there are not, of course, I have a lot of questions to Brian on space resources. Are you following the current discussions in the legal subcommittee on the scheduled informal consultations and the mandate of a possible working group? Do you see that it's going in the right direction, or are you skeptical?
I couldn't tell you. I have colleagues who, well, not in Vienna, are in Vienna as much as many of us at the legal subcommittee who are tracking this quite closely. Mm-hmm. Relatively new to being, back in government service and engaging with these issues. So I don't have enough of a sense to really evaluate them.
And interesting, in talks with the US government, US representatives, often the question of the moon agreement arises. And interestingly enough, I hear different opinions. Some say, well, the moon agreement is really irrelevant and it's outdated. Others say, well, it has an interesting basis, namely to create an international regime based on a treaty, which is a solid legal basis. But the reality is so that currently in all countries, not only in the United States, but also in the United States, the readiness to agree commitments set by a treaty is lacking. So even if in principle and in the abstract, the moon agreement provides a basis, it could provide a basis, it's just not realistic that this will be a tool for the future. Can you also confirm this observation that reactivating the moon agreement is perhaps, even if in principle an idea, in practice, in reality, it's not probably the way to go forward?
Sure. I mean, I'll offer some personal views on that. So as I observed a minute ago, one of my great learnings from being in the private sector, particularly engaged in an entity trying to press forward the exploration, the state of the art of exploring space resources, was that we will eventually need to solve this problem, to find a way to allocate something akin to rights to the resources in place, which my understanding was that was sort of the gravamen of the moon agreement. And so it's understandable to sort of start there and think, well, there is some international scaffolding. Is there a way to utilize that? I mean, that's a logical question to ask. You also observe, I think correctly, that many legislatures, including in the United States, are not in the habit of assenting to treaties, which is sort of an unfortunate circumstance, but it's a constraint that we have to sort of design around. And that if you look at certainly the United States Senate, the rate at which it has ratified what are called the device consent treaties, the kind of international agreements that require the supermajority of the Senate. It's exceedingly rare. And so now that's not for all international agreements. There are many international agreements that the United States and other countries, by analogy, can enter into, relying on the executive's constitutional authorities. And that is how much of international cooperation has proceeded during my professional lifetime as a foreign ministry lawyer. But it is limiting, as you observe, of the solution space.
Yeah, so we keep fingers crossed to the efforts by Stephen Freeland and Andrei Mistal to at least create a working group under the legal subcommittee, which discusses substance and not a form. So when they come to the step forward to establish a working group, then the discussions can start. What would be the contents of such an agreement of? I think the two main issues are to avoid conflicts, because that was clearly also presented, that they can easily emerge. And the second would be to provide legal certainty, that it is what is lawful, what is not lawful to a certain extent. And these two objectives, avoiding conflict and provide some legal certainty, and then we would need to go forward to enable that, even if it's a non-binding instrument. We will see, but I mean, that's certainly always usually the purpose of the law as such. A binding law tries to avoid conflicts and give legal certainty, which a non-binding instrument apparently cannot do. But the way forward is, I think, promising. I would surmise that I'm glad to see that there is a lot of cooperative effort and a positive attitude I've seen during the subcommittee, which brings hope that instead of unilateralism, multilateralism is here the way to go forward, and it's broadly accepted. So I think we can perhaps finish here on a positive note, unless there will be some other questions. I still wait for questions in the chat or by the audience, other remarks. Otherwise, we would leave it at that a little earlier than 7, so that Brian does not have to rush, and we can continue with our other two speakers, which have also very interesting things to say. I'm so glad that we have such a broad variety of space activities to discuss. Thank you very much, Brian. It was a great pleasure to have you here with us. I hope we can meet again soon in Vienna and talk at the premises of the United Nations or the University of Vienna, and to continue our conversations. Thank you very much.
Thank you, Irmgard. The pleasure was mine. I look forward to the same. My apologies for having to leave early. I'll look forward to watching the recording of the rest of the panel later. Take care.
Thank you. Thank you. Goodbye. Take care. Yes, so let's now continue with our third speaker, which is Elina Moroshova, the Executive Director of the Sputnik International Organization of Space Communications, which is an intergovernmental satellite communication organization headquartered in Moscow. Elina is responsible for relations with Sputnik's member countries and the UN system, including the Committee on the Peaceful Uses of Outer Space and the International Telecommunications Union, as well as with other global and regional space-specific and telecommunications organizations. She also teaches a course in international space law and telecommunications law at St. Petersburg State University. Elina, it is great to have you here.
Thank you very much for such a nice introduction. Hello, everybody. Good evening, good afternoon, good morning to all of you. Whenever location you have, it is so nice to see many familiar names, and I hope you are enjoying the legal subcommittee. I will share my screen.
Yeah, and also the first question that goes to you is, please briefly describe the space sector you're going to talk about. And second, to what extent is this sector private or public?
So all my space-related experience is accumulated in the field of satellite communications, and probably many of you know that it is good luck for me, because this area of space activities remains to be the most widespread, essential and advanced. And just to assess which key role satellite telecommunications have in our daily lives, we can refer to some statistics provided by Satellite Industry Report. It is Satellite Industry Association. They have some figures for 2019. Of course, 2020 was very different year, but I think that the trends and the main shares will be the same. So in 2019, the global space economy amounted to $366 billion US, and 74% of all revenues which were generated worldwide were for the satellite industry. And among satellite industry, almost half of this huge amount of money was accumulated by satellite telecommunications. We know that SATCOM includes television, fixed satellite services, radio, broadband, and mobile. And comparing with global space economy, it is about 1/3 of the total income. It is 120 billion, so a big amount of money and lots of opportunities for this space sector. So if we look at some local specifics, I mean, of course, Russia specifics, because we are headquartered in Russia, and consider whether this space sector is private or public, we have two major, or just two, satellite operators. I mean, those operators which have their own satellite fleet. So the first one is Russian Satellite Communications Company, RSCC. It is the eldest operator in Russia. It is currently one of the top 10 operators worldwide. It has 20 satellites in the GSO, and it is 100% state control. So it is a federal state enterprise. It means that it is governmental from the very beginning, from the budgets, from the policy, from purchasing satellites, for launching satellites. It is our state company. We can have something close to private operator. It is Gazprom Space Systems. Many of you can recognize the name of Gazprom. It is Russia's major energy, oil and gas company, and Gazprom Space System is its subsidiary. So it is the second biggest satellite operator in Russia among the two operators. It is twice little in the respect of GSO satellites. It has 5. And even though legally it is a private company because it's joint stock company, but through Gazprom, through direct and indirect involvement of state, we can say that it's also approximately 50% state control company. So this is the main picture in Russia. Of course, we also have a number of other companies, small companies, which do not have their own satellites, but they lease satellite capacity, provide additional services, build infrastructure and ground segment. And those companies are indeed private. But being private, they cannot afford being a full-fledged satellite operator. And these companies can also use not only Russian satellites capacity, but satellite capacities from all operators which are existing on a global scale. You can see on the slide some names. Please do not try to find any order or rating or whatever. It's just a random number of names which you probably are well aware of. And when I say that Russian companies may use capacity from Russian satellite fleet and from foreign satellites, there do exist some limitations. For instance, Russian operators or Russian customers cannot use foreign satellite capacity for some specific services, which are very close to state security and some other principal things. For such kind of services, you can only use Russian satellite fleet. It is a law. And where can we find Intersputnik in this picture? So Intersputnik is intergovernmental satellite organization, and interestingly, it doesn't have its own satellite fleet. There is a number of reasons, including the reason that we have member states which do not subsidize, they do not make contributions to Intersputnik, they do not contribute to share capital or whatever. There are no money received from member states which can be pooled and spent for a satellite, for instance. As an entity, we tried to refer to bank loans and so on and so forth. And of course, if we say about private or public, I would compare Intersputnik with private capital just for this reason, because we do not spend our member states' money, we generate income. And even for Intersputnik, it is not possible to have its own fleet, but what is good, we can use satellite fleets from our member states and from any other entity, because satellite market is open and everybody can lease and sell capacity. For making our presence in Russia, we've established our subsidiary. It is ECSL company. It is a Russian operator, which can be referred to this second type of companies in Russia, which just resells satellite capacity and tries to make some additional services with that. And to have a similar model in other member states, Intersputnik has its program for the development of business in the field of space communications. And this program provides interest-free loans to any company which is involved in this space-related activity in our member states. Either it is registered in our member state or it just makes business in those states, and we can support their activity with some loans. Finally, I would speak about some specificities of Intersputnik, which can explain my further answers to the questions. So first, once again, we have a very interesting status. So Intersputnik is intergovernmental. So it performs its international function as many other international organizations do. At the same time, we conduct satellite operator business. And it is not very typical for intergovernmental organizations, but it is our history that we have chosen this way to move forward when it was clear that Intersputnik must engage in commercial space activity. We didn't split into different entities. Many of you know the example of Intelsat, Eutelsat, and Inmarsat, which divided their international organization and commercial entity. We have two functions or two heads within one organization, and this is 100% legally, of course. It is something what is written in our statutory documents. So we are doing commercial space business as one of the avenue of our activities. Among our 26 member states, only 9 members have their own satellites. It also can explain why we have to play on the market as a usual operator as all the other. But also it is important to mention that our member states are generally represented by the so-called telecommunication administration. So those entities which are engaged in cooperation with International Telecommunication Union. Only 2 member states of Intersputnik are represented by space agencies. So we are much more dealing with telecommunications than with, I would say, space in general. And some other member states are represented by other authorities, which are neither telecom administrations nor space agencies. Since we are headquartered in Moscow, and we of course must respect Russian laws in that extent, which is not prescribed or specified by our statutory documents, we closely follow these legal processes which are happening here, and sometimes we are invited for different discussions to the extent relevant to Intersputnik. So briefly, this is the answer for the first two questions.
Thank you very much. Very interesting insights, which we usually do not have. Thank you very much for explaining it so clearly to us. Now, how were you involved in the review or development of national space law and policy, space law or policy, and which were the biggest challenges?
If we speak about space laws and policy, we were once invited by our member state to give advice on space law, which is now in the process of being drafted. Since this state is a European state, and we know for sure that European Space Agency has lots of experience in supporting such emerging space legislations, it was of course better to continue this dialogue on another platform regarding our involvement in Russian legislation making process. Once again, because of our main focus of activity, we are more engaged in those legislation which are connected with satellite telecommunication services, and so on. For instance, in 2014, there was a huge amount of new laws generated to regulate the access of Russian companies to foreign satellite networks and foreign players to Russian satellite networks. And we were formally invited in this working group. There were several different decrees in this big bulk of legislation set. And among, except us, there were a number of big players. In Russia, it is a general practice that every piece of legislation is open for public discussion and everybody can comment on it. And it is even not necessary to represent a major private player, for instance. Everybody can be heard. And of course, some major players are included in working groups. So they are established by the governmental bodies which are in charge of this or that legislation initiative. And what we can contribute to such dialogue was, of course, our special status, because, you know, our satellite networks are neither satellite networks under the jurisdiction of Russian Federation, nor satellite networks under the jurisdiction of foreign states. So those discussions revealed that there are several exotic cases like Intersputnik, which cannot be covered or just foreseen. And every time when IGOs are involved in this or that piece of legislation, we are invited to share our experience. So this was the major piece of work in this sector. But once again, the process is the same for any legislation act. So there is an open discussion, there is a working group, there are invitations from the sector and including from the private sector, and then the discussion is open to everybody.
Thank you very much. And the last prepared questions would be, which recommendations would you have for the future for legislators, in particular your telecommunication sector, for national legislations?
First of all, I would emphasize something which is obvious, I suppose, the importance of dialogue with private space actors, even not only private, but with every stakeholder in this or that process, because, you know, there is an expression, something about devil and details, because nobody knows better how this or that law will will be implemented unless this entity is going to implement your initiative. For instance, even in Russia, where national satellite market is somehow protected and supported by the government, including by limiting access to foreign satellites, it can be fully respected and followed, but some details can be improved to make lives easier for those who will be following this legislation. Also, I think it is important to pay attention to regional associations, groups, or whatever. For instance, in Russia, we have a headquarters of the regional commonwealth in the field of communications. It is one of the 6 regional telecommunications organizations which are represented at the International Telecommunication Union, and they have a very good power to harmonize legislations between CIS states, so states from the Commonwealth of Independent States, where the major number of post-Soviet countries are present. So this is for the purpose of harmonization, for the consolidating position when you stand at international fora. This is a very efficient tool, and such organizations are usually open to private sector as well. And finally, I would say that the role of private sector is much greater than people can think. I mean that private sector can easily and naturally move forward the purposes of this or that state. For instance, I had an example which can illustrate this idea. At Intersputnik, we were negotiating a process of establishing a satellite system for a space emerging state. And this state was not a party to registration convention. And we were negotiating the launch of its satellite through a national company of the state, which was party to the registration convention. And when these 2 parties were discussing how the satellite will be launched, the launcher provider demanded that there is a guarantee that the satellite will be registered. And our emerging spacefaring state said that it was not a party to the registration convention, and it must not or was not obliged to register. And the result was that the satellite launch provider said that it was not very much interested in all this international space law thing, but these were the requirements. If you want to go to space, if you want to buy a ticket, please follow these not international law obligations, but this sale and purchase agreement with launch provider. And in fact, it was a bit shocking experience because we are all space lawyers and we can say where you are obliged or not obliged to register, but the practice is a bit different. And this shows how strong private actors can be in promoting the interests of their states through some national legislation provisions. So I think that this cooperation with private sector can be a win-win situation when you not only hear and try to implement some ideas to make life of your private sector easier, but you can also move forward your ideas through your private sector. So that's the outcome of this experience.
Thank you very much. It's a really very, very illustrative example you mentioned about the need to register. Even the state says, well, we don't have to, but the private launch service provider says, yes, but we don't get the contract. So how international law can be implemented by private actors. That's a very beautiful example. Thank you very much for this. And for the entire presentation and the thoughts you were putting into the questions which you needed to prepare. We asked you to prepare. So it's really very valuable. I think this recommendation, the last recommendation, is really very valuable for all of us, and giving this nice example of the need to register. I have many, many more questions to you, but I really would like to open the floor to questions from the audience or from other panelists. Otto Kudelka, please, of course, put the question to.
Thank you very much. Thank you for this very interesting presentation. I have a question. You mentioned that Gazprom has their own fleet of satellites. Is, for instance, pipeline monitoring from space, is that an application that's being followed by Gazprom using their own infrastructure?
Yes, they are now involved in deploying a constellation of satellites which are called SMOTR. So those 5 satellites which are placed on the GSO, they are more for rendering fixed satellite service and for other consumers. But of course, they are also deploying some facilities that help to serve their mother company, Gazprom. So that was one of the ideas why they decided to establish their satellite provider to make the demand of all the group of companies satisfied by their own facilities. More so, they are now establishing a construction process to build their own satellites. So they are trying to be quite independent in all aspects.
An additional question of interest, are these Malnya and Tundra type highly elliptical orbit satellites, are they still being operated or have they been retired?
In fact, it was the Soviet Union, I think, who was considered to be the first to use these elliptical polar orbits. And now we have still several satellite projects which provide using this type of orbits. For instance, there are several more constellations which are under discussion in Russia, and projects like Sfera or Marathon, and also Express RV is a satellite constellation of Russian satellite communications company, which will also be using some polar regions to provide communications across the globe and to serve our polar regions, which we have in Russia.
Thank you.
Thank you very much. Peter Fischer, I see, has raised his hand. Professor Fischer, former professor at the University of Vienna. You have a question, please? You have the floor. Peter Fischer, I see your hand is raised. Perhaps you have to, you have to unmute your microphone. We cannot hear you. No. But still the video camera and the microphone as well. We cannot. Now it works. Thank you.
By your presentation, Leader Morozova, I was interested in the legal basis for the licensing systems for launching satellites in Russia on the basis of the various forms of satellites. The licensing, is it a unilateral act by the institution, or is it a contract, a kind of concession? I know that Soviet Union and Russia is now using a concession contract system to allow corporations to operate in Russia. Now, is this licensing system also applied to launching satellites? Is it a contract in the form of a concession, or is it a unilateral act by the organization Intersputnik, or whatever you have here mentioned in your excellent presentation? Thank you.
Thank you very much. I think, Elena, you can go directly to answer this question. Thank you.
Thank you very much for this question. Sputnik, fortunately or unfortunately, doesn't launch its own satellites. So we have never applied for a license. For those activities which can be regarded as those which require licenses, we also do not need licenses because of our intergovernmental status. You know that an authorization by a state can be given either by a license or by international treaty, like in the case of Sputnik. But regarding licensing in Russia in general, I think that it cannot be assessed like a unilateral act, because we have a regulation on licensing, and launching satellite is of course a specific space activity which is obligatory to be licensed if somebody wants to perform this type of activity. Russian Space Agency Roscosmos is the entity which considers applications from those companies which want to be engaged in this or that type of space activity. And there is a number of requirements, both technical and with regard to people resources. I mean, some expertise must be confirmed, and then the entity will be granted a license. But usually, I mean, when I think when you mean this type of consortia, these are those which use facilities of Roscosmos and other entities in Russia by establishing joint ventures with Russian participation, and they are licensed in this same manner. So they must apply for a license and prove that they have facilities, they have experience, they comply with all the other requirements, and then they are granted a license. And Russia also supervises space activity, because license can be suspended or terminated if the licensee can no longer comply with requirements, and the license is granted for a specific period of time. So this is how authorization and supervision are performed in Russia.
Okay, thank you very much.
Thank you very much. I think I have another round of questions. I've seen 2 hands raised, but Leslie Tellen has removed his hand. I wonder whether you are still interested in putting your question. And the second hand is raised by Elizabeth Chua. So Les, you were first initially. Do you still want to put the question? Or then I give the floor directly to Elizabeth Chua. So please, you can unmute your microphone or write it in the chat. You don't have to activate the video if you don't want to, but we want to hear your question or read your question. Elizabeth? I don't, oh, it must be a mistake. No hand raising. And Leslie, perhaps the same. Okay, so then perhaps if we have some further questions, we can put them afterwards. So perhaps they fit together a little bit with the following presentation. Thank you, Elina, for the time being, but I'm glad that you stay with us until the end of the event for half an hour. I think that we might perhaps in the end have some questions for the 2 of you, but for the time being, I think we must move on. And thank you again for your very interesting presentation, your contribution and thoughts. Thank you. So now the next speaker is Otto Kudelka from Austria. He is professor and head of the Institute of Communication Networks and Satellite Communications at the Graz University of Technology in Austria. He developed the first Austrian small or nano satellite, the TuxSat-1, which was launched together with UniBright as the Bright Austria constellation in 2013. This made him to be the Austrian specialist in the area of small satellites. Otto, the floor is yours.
So thank you very much, Irmgard, for your kind words of introduction. So it's my pleasure to talk about my part, and I will share my screen. So I hope you can see my slides in full screen.
Yeah, very good. Thank you.
Okay, so my own involvement in space activities, I'm professor of telecommunications with a specialty in satellite communications, and we have been building SATCOM systems and operating them. And since 2004, I'm also engaged in small satellite activities. As Professor Mabo said, we developed the first Austrian satellite, Bright Austria, which was launched in 2013. In February, more than 8 years ago. It's still fully operational. It's an astronomy satellite, and it measures the brightness variations of massive luminous stars. It's part of a constellation of 5 satellites, 2 Polish, 1 Canadian, 2 Austrian, and it's collecting still very good data. Then the second mission we have been in charge is the development of OPSAT. It's a technological satellite built for a European Space Agency and operated by ESOC in Darmstadt. So it demonstrates new mission operation services and conducts a number of very challenging software and hardware experiments. And the third one is being in development together with RUAG and Cyberstorf laboratories in Austria. This is a mission to measure, on the one hand, the radiation environment in LEO orbit, and the primary mission is to do altimetry to measure the height of sea waves or of glaciers using the direct and the indirect signals of navigation satellites. So, space sector, Irmgard, if you permit, then I move just on.
Yes, please. The questions are the same. So first describe the sector and to what extent is it private and public? These are the 2 first questions for everyone. Thank you.
Yes, I mean, from all the space applications that you have seen in the previous presentation, satellite telecommunication has always been and still is financially the most successful space applications. I mean, we have just as example, SAS and Eutelsat, very big operators, started in Europe, but they have bought capacity in the Americas and in Asia as well. So the commercial services, TV broadcasting has been the cash cow. Business case used to be rock solid, but due to the paradigm shift, the young generation is watching their programs not linearly. They watch it over the internet. So the linear transmission is getting less important, still is important, but moving to internet is an activity which exists. I mean, the first internet by satellite systems have been used in the early 1990s, and now it's gaining more impetus. Navigation and Earth observation are also very important space applications. They are largely institutional. Public services like remote sensing, disaster management, cartography, and also, I mean, we have the different systems like Galileo, GLONASS, GPS, the Chinese Beidou, but basically the public pays for the service. Yeah? I always ask the question, how many people would use their navigation service on a smartphone or in their car if they would have to pay 15 euros a month? Not as many as we have right now. In the US, we have private and commercial actors which are increasingly involved. I mean, Blue Origin, SpaceX, Planet Spire, for the small missions, just to name some. I mean, it's not exhaustive. But still, government contracts, particularly for launch services, are crucial. Yeah, so SpaceX, to an important part, lives on NASA contracts for the Dragon and the Crew Dragon, and for missions by the Department of Defense. And in Europe, new space companies, which are growing all the time, but they still live to a significant extent directly or indirectly from ESA contracts. I give you a few examples. I mean, Planet, founded in the US, is a startup with a constellation of more than 180 CubeSats, with a ground resolution for Earth observation of 3 meters, plus they bought up 5 rapid eye satellites from Germany with 5-meter resolution, larger satellites plus 21 SkySat satellites, which belonged once to Google with 0.5 meter resolution. And the small ones have the advantage of a very high revisit time, because you have so many satellites, there's always one overhead. Another example also started as a startup company in the US, but Aspire and Planet, they have lots of offices in Europe as well. They have around 150 CubeSats called Lemur, and the main applications is detecting of AIS and ADS-B signals. These are navigation signals from ships and from aircraft to improve maritime and aircraft safety. And the first application is for weather forecasting using a method which is called GPS occultation, but they sell it to meteorological offices. But still, to a significant extent, that's institutional market. And then, of course, we should not forget the mega constellations. I must say, the big hype, which was there 2 years ago, is a little bit over, I would say. OneWeb planned 648 satellites in 2020. It went into receivership and it was bought up by the UK government and an Indian investor. They stopped last year at 78 satellites, so they replenished. They have now 228 satellites in orbit. Application was originally private internet access, but their main application, as it's published, are internet services to northern latitudes and military communications. And then let's go to SpaceX Starlink. I mean, when you read what is published, so Elon Musk wants to launch 40,000 plus LEO satellites. I made deliberately the question mark there, because as a telecom engineers and all my colleagues share my view, nobody requires 40,000 LEO satellites for global coverage, and they have only 40,000 ITU filings. So there's a bit of mismatch. They launched already 1,500 satellites, but when you want to find out about the performance and the service, you find very little. So on the internet, you find a ground station with this picture, which I find is a very poor picture of a mock-up. This can't be the real thing. Some friendly customer trials is ongoing. If I were asked where I put my private money, I would go into the Canadian Telesat Lightspeed system. They have a more moderate constellation of 198 LEO satellites for internet access, and Telesat has a decade-long track record in telecommunications. So, I mean, here we have private activities. I mean, OneWeb was founded by Greg Weiler. I mean, SpaceX belongs to Elon Musk. Telesat is also a private company. So we will have to see how successful these LEO constellations for global internet access is. But if you need internet from satellite, you can do that very well with existing geo satellites, and there are many successful systems for that. So with this, I hand over to Irmgard for the questions.
The next question, yes. To what extent and how were you involved in the development of a national space law, and what were the biggest challenges which you saw?
Right. So actually, we got in 2005 a contract by our National Space Agency to develop the first Austrian small satellite, which, as I said, is part of a constellation, a very successful constellation. And this triggered the discussions for a regulatory framework. And the first question was really, I mean, how do we register that? I had the privilege taking part in the Corpus meeting, so I was well aware, although my background is an engineer, that registration is required. So it turned out that a comprehensive Space Act will be needed, including authorization and supervision. In Germany, for instance, they have still not in national space law, they solved the problem because they have been launching satellites since the early 1960s. They had an amendment to a registry which is used for aircraft. Yeah, but we have done it properly. And Professor Mabo, I always call her the mother of Austrian Space Act. It entered or was set in force in December 2011. The minister at that day told me once, I love the Austrian Outer Space Act because this was the only law which I got through Parliament without any negative comments. Okay, so something quite good. So I participated with respect to technical and operational issues, which was very interesting. And I remember there was a meeting where a risk assessment question came up. It's a very logical question. So how dangerous would that be? And the federal ministry then gave an external expert contract, and an expert report was being prepared, showing that with such a small satellite being properly placed in a LEO orbit, the risk is practically zero. I mean, with more and more small satellites being launched into LEO, the risk for collisions is, of course, increasing. So, I mean, I will touch that a bit later.
Yes, thank you. Thank you very much. This brings me to the last question. Which recommendations would you have for the future?
Right. So, I mean, the Austrian Space Act is very well written. So even a engineer like me can understand that properly. But I mean, there are some challenges. So for instance, there is one paragraph which says you have to set up an insurance to minimize the risk. So the amount would be minimum for 60 million euros. But for research entities and small startups, this could be a potential showstopper. Luckily, in the Space Act, there is another paragraph which says you can apply with the ministry responsible for space activities for an exemption. And this is something that we are doing right now for our third satellite, for the Pretty mission. The registration process is pretty straightforward. It's nothing complicated. You deliver all your data to the Space Ministry, which is the Technology and Innovation Ministry, and then they inform the Foreign Ministry, and they then make the notification with the United Nations Office for Outer Space Affairs in Vienna. There has always been the myth around, and frequency coordination with the ITU and proper frequency filing is very important to avoid harmful interference. And there's always the myth that this is a very, very complicated process. It is not. Yeah? So there are very good tools from the ITU. So you fill in a database. So this is done relatively quickly, and then through your National Radio Regulation Office, the ITU is notified. But what is quite surprising is that there is a not negligible lack of knowledge of ITU rules and regulations, particularly from universities who build CubeSats for educational purposes, but even for some startups. So there is quite a mismatch when you look into the database of active or satellites in orbit and how many of them are properly ITU frequency coordinated. So there are quite a number of pirate satellites, which is a problem because you can interfere with others. And another point which is getting more and more critical, this is the avoidance of space debris. So I would really recommend that in the future, a satellite, if it's for demonstration purposes or for educational purposes, should be brought in a very low orbit so that it decays within a couple of months. In the Austrian Space Act, it is said that you have to comply with the 25 years rule. so that you have to select an orbit if you have no active deorbiting mechanisms. Then by the natural decay, the spacecraft shall not be in orbit for more than 25 years. But there are now technologies available, little thrusters, ion thrusters, or deployable sails to increase the ballistic coefficient of the satellite, so that after the active phase of the satellite, you could deactivate that. Yeah, I mean, I also heard some new space companies said, yeah, our satellites are so cheap. If something fails, we can just replenish it. Yeah? If it's not working, then we just replenish it. But a non-working satellite, in particular in a LEO orbit, is space debris, and the risk for a collision with other active satellites is increasing. So that was my last point here. But I'm also happy to ask any questions which you might have. Thank you for your attention.
Thank you very much for this interesting, fascinating overview of the small satellite sector. Not only the Austrian contribution, but very interestingly, an overview of famous names and how they developed and how they are currently. I do have a question in the chat by Veronique Claude. She writes, how to increase knowledge of ITU rules and regulations.
Yeah, this is a very good point. I mean, there have been conferences, and for instance, the International Astronautical Federation at the annual big congress, there are also sessions where these rules are being touched upon, and also, I mean, whoever builds it, so for instance, if a small company or a university develops some space project, then they have, if they want or not, they have to get accustomed to that. I mean, if you have a national space law, yeah, like Austria, in Austria, it is basically impossible that somebody can claim ignorance, and I have not frequency registered properly, because to get the mission approved, you have to apply for authorization. And if you can't show that you have not properly coordinated with ITU, permission is denied. Yeah. So of course, I mean, there are countries who have a National Space Act. Then the question is how well the policing is being done there. So of course, I mean, it's getting better and better, because more and more countries, I learn from Irmgard, are implementing national space acts. And with that, the situation should get better. But nevertheless, strict adherence to ITU rules is not always given as it should be. So for instance, also from theoretically knowledgeable institutions, I have heard, okay, why don't we use Iridium as an inter-satellite link, because there's this LEO constellation. You can't, despite the fact that people have done it, but it was not according to ITU rules, because the frequencies have been assigned ground to space and space to ground. But if you make a link from a LEO satellite to an Iridium satellite, is space to space, and the frequency is not granted for this. Yeah?
Thank you very much. And indeed, there are several conferences, but the easiest way perhaps would be just to go to the UNOSA website, because the
Yes.
UNOPOS and UNOSA realized the lack of knowledge when we talked extensively about small satellites activities, when it started, a new trend, and so the ITU worked together with UNOSA to publish a brochure. I think it's called, Otto, correct me, it's called handbook or guidebook or so. So guidebook on small satellites. And this is really an easy and show a relatively short brochure, but it contains all the necessary information you need, and also the way you find further information. So links for further information, databases, tools which can be used and which have been developed by ITU in particular, but also the legal basis and basis for small satellites in general, because it's sometimes, and it has been underestimated, that these are small space activities as any other activities, and they fall under the scope of application of the Outer Space Treaty, the Registration Convention, Liability Convention, everything applies. And there was some need to raise this awareness, because at the beginning it was considered as like amateur activities and university activities. They do not have to comply with all the strict rules, and they can operate, I think there's a publication, operate under the radar. But in fact, they do not operate under the radar. And that's also the point of this publication, that it should not be regarded as operating under the radar. And now I think the awareness has increased a lot, and also the US has amended its law and given some supplemental information to small satellite operators, that they are not afraid of the legal framework and the requirements of the law. I have quite a long chat, you see, by Joanne Wheeler from the UK. Thank you for the initiative for this event and presentations. Questions for all speakers. In UNCOPO's discussion, much has been stated about national implementation, which is key. National implementation of best practice registration, LTS guidelines, etc. When I support governments and national regulators, I'm very mindful of forum shopping, which is a real challenge now in the last 5 to 6 years. We need to prevent the race to the bottom in relation to regulation and encourage a race to the top, well-balanced, effective, sustainable, and best practice. But how does the international and national community ensure this? How important is the engagement of commercial companies in this issue? For example, could best practice licensing be linked to environmental, social, and governance issues? Or do we need to implement something like ITU resolution 49 for licensing? Not easy. Thank you. Perhaps this is a question to you, ITU resolution 49 for licensing. Do you want to take this up, Otto?
Yes. Well, I mean, I hear sometimes the point, this is over-regulated. Yeah, so ITU is over-regulated and too complicated. But I don't agree to that, because spectrum is scarce. Yeah? Spectrum is a very scarce resource, and it has to be properly coordinated. Yeah. Otherwise, there's interference among services. There's an interesting development. And last week, there was a relatively big ESA conference on small satellites and telecom systems. So there are more and more developments for using optical communications, yeah, where bandwidth is huge, enormous, much, much more than in radio frequencies. Their spectrum is free, because I mean, spectrum, apart from very few parts, you don't have to pay a license fee. So this is, for instance, you don't have to pay for Wi-Fi. This is a very small part of the overall radio spectrum. But for anything else, you have to pay, and sometimes you have to pay billions of dollars or euros. So for instance, when we use our cell phones, yeah, our operators had to apply for spectrum, and they paid for spectrum, sometimes more, sometimes less. But you, as the customer, you repay the operator for their costs for the license fees. Yeah? So our friend Attila Matas from now retired from ITU, he always said there is no such thing as free spectrum. The optical is for the time being free. Maybe if everybody uses optical communications, well, we will see, because governments are very innovative to grab money from users. But on the other hand, the risk for mutual interference on optical, because the beams are so narrow, is very, very limited.
So the use of interference, the risk of interference is limited in the optical spectrum?
Yes.
So we still, we still have a lot to learn from engineers. I really appreciate very much this exchange of views and information across the disciplines. So we had 3 lawyers here on the podium and 1 engineer, and you see how lively the discussions becomes when we have this interdisciplinary setting. And I think the other remark by the UK representative is, of course, implementation is important, and what is also the purpose of this event is the role of the private actor. I mean, we formulate it in a way, and then with a top bottom-up approach in a way of the development of national space law and policy. So this was actually the question we put here to our speakers. So in the development and review, but the next step, of course, then would be implementation. And so it goes back from the legal basis to implementation and practice, and here the role of the commercial sector is also important. It was not specifically addressed in my questions, but Elina made this very beautiful example where the private contract was not given when there was a lack of registration. No, this is a good example of how the private sector can help in the implementation of international law and international best practices. Do you agree, Alina? I think that was the purpose of this example, no? To show that the private sector is not only there in the formulation and demanding of specific space laws and policy, but also when then it comes to the implementation.
Yes, exactly. It was my idea to say that sometimes private-to-private relationship can be even stricter or more demanding than the rule of international law. And since there is always a challenge how to implement international law, how to enforce even mandatory provisions, sometimes partially it can be done through national legislation and private actors, even not only private. In fact, this type of filter is available to those spacefaring states which can provide some unique space-related services, for instance, like those launch services, whether a public or private launch provider, it can contract on its own requirements, on its own terms. And I think the main approach can be equally valid with regard to any emerging type of space activity. For instance, now we talk a lot about lunar activities, space resources, or in constellation of telecommunications satellite around the moon. In the near several years or even decades, we can list those countries which will be available to sell tickets to the moon, and it would be very much important or useful to pool their resources and to negotiate this new order, which will be mandatory for all those who would like to join lunar space economy or something like that. But if with your admission, I would just wanted to add on the Joanne's questions about the flags of convenience or whatever this type of flags are called, I think that the problem of finding a balance between the needs of a state and its requirements implemented in its legislation was raised by Stephen Freeland in his talk. And I think it very much depends on the priorities of the state. For instance, we had a Russian company which wanted to produce small sats, Dauria Aerospace, maybe somebody knows this company. It was one of the first really new space startup in Russia, but there was a lawsuit with Roscosmos, and it was evident that this private company, Dauria, was not supported in this court case, and it was insolvent and went through bankruptcy. But there were those people who wanted to continue this business, and they just moved to California or somewhere else. And it was the choice of this state in this exact example, whether they would like to be strict and demanding on several provisions, or they would like to be supportive of private activities. I think your question comes from very different jurisdiction. I remember your speech at the Ditchley Foundation Symposium. You raised this issue that some states are very much concerned that when they try to be good on the international level and implement their international obligations, then can lose their private activity and private sector. It very much depends on the state. I think in Russia, there is no such a problem because Russia is rather strict with all actors, including private, and companies just need to comply because you cannot run the, for instance, satellite services in Russia if you are not registered in Russia. If you're registered in Russia, you have to comply with all national requirements.
Yes, thank you very much. I think we are almost done with our time, but I see two questions. One is in the chat and one is Professor Fischer raised his hand. I would say we combine these two questions as the last round, and then I ask the speakers to answer those quickly in the final round. Professor Fischer first raised his hand.
Thank you very much. I don't want to take too much time. The short question, I found it most interesting to when you spoke, Elena Morozova, about the organization Intersputnik. You said Intersputnik is an intergovernmental organization, but is under the jurisdiction of Russia. And this is very unusual because intergovernmental organizations, they have a headquarters agreement and they enjoy a sort of international privileges. And is that not the case here in Russia? Do they have to comply with Russian law? Do their officials not enjoy diplomatic privileges? And could you say a few words? It is a very unusual organization. It's very interesting, actually.
Yes, thank you. And from the chat, we have the concern by Leslie Tenen with regard to licensing and best practices. He raises the issue how to protect the global public interest regarding ventures to send personal items, which to everyone else is just trash, or the created remains of humans and pets. We know these are commercial services which are offered in the internet. You can send your remains to space, and this creates a problem. And no, we can put this on a question on the table. This question: how does this relate to best practices? How would it be compatible? So I pass on these two questions to the panel, and I see Otto Kudelka will probably like to take one or two of the two questions, and then Elena to give us a final observation on the legal status of Intersputnik. Briefly, I think we must be brief because we have already 2 hours of time, but it's an interesting question, certainly.
If I may comment to the question of putting personal items or whatever into space, this should be strictly forbidden, yeah, because this is pollution of a precious resource. Namely, you increase the risk of a collision because these things are typically brought into a LEO orbit, because otherwise it would be too expensive. Then, I mean, if I would put my smartphone into space and it would be there for 50, 100 years, then it wouldn't do any useful job, but it could collide with and damage anything. So maybe I'm too strict, but I would require a demonstration that whatever space object you bring into space has to have a useful service to the public. And I doubt that you can demonstrate if you put some personal item, if it's precious to yourself, but it's certainly not something that's precious to the global public.
Thank you very much for these clear words at the end. And Elina, please, a few words on the legal status of Intersputnik with respect to the question of Professor Fischer about immunity and whatever.
Thank you. I would love to spend 2 hours, but I will be short. Indeed, Intersputnik is an intergovernmental, so as an organization, it is not subject to any national jurisdiction, neither of Russia nor other 25 member states. But there is a difference between our statutory activities, like rendering satellite services, telecommunication services, and all other activities. For instance, it is the rule of law in Russia that even intergovernmental organizations, those who are headquartered in Russia, must comply with labor law. For instance, with regard to labor law, epidemiological protection, human well-being protection, and some other fields of law, our activities are under the jurisdiction of Russia, and we must comply as any other Russian entity. We also have a headquarters agreement with Russia. We have privileges and immunities agreement, but once again, there is a big difference. For instance, I'm a citizen of Russian Federation. I have no privileges and immunities in Russia, but when we have foreign employees working for Intersputnik, we have them from Bulgaria, for instance, we have from Mongolia. They are immune and privileged in Russia, so it depends also on your citizenship. With regards to the scope of privilege and immunities, Intersputnik is not the best example. I mean, we do have immunities and privileges, but not as much as some other organization can have.
Thank you very much. Thank you
very much. Very interesting. Yeah, we could indeed continue for much more time on this issue. Perhaps it's a good idea for a next theme of a side event of the NPOC Space Law National Point of Contact for Space Law Austria, the different qualities of intergovernmental and international organizations which are active in space. You yourself mentioned the interesting privatization of Intelsat, privatization of Eutelsat, privatization of Inmarsat. What happened to them? How do they operate today? Did the governmental representation vanish, or is it still there? Very interesting. Food for thought anyway, in any case. I thank you very much for your active participation. I thank very much the panelists. I thank for the interest of the audience, which remained until so late in the evening. We passed a little bit our time. Thank you very much for staying on with us, and let's stay in contact with our various different activities. You now have our email address, and soon we will have a relaunch of our website as well, which you will not miss. I'm sure we'll send out information. Thank you very much again for joining, and I wish all of you who are active in the legal subcommittee a successful continuation of the week and successful completion of your work during this legal subcommittee. All the best, and take care, stay safe and stay healthy. Bye-bye.
Thank you. Bye-bye.
Bye-bye. Bye-bye.
Thank you. Bye, everyone.